So very happy to be here, and I want to congratulate everyone for getting up this morning to listen to a panel on IP. I'm basically just here as a warm-up act for two great speakers, so you can just try to wake up during my speech. A lot of the discussion in the papers, I haven't read all the papers and not all of them are available, but I think that where we intersect very much with the other topics here is the notion that governments regulate, as basic as that sounds. That power to regulate is being increasingly challenged, not by other states, which was traditional international law, where states made treaties in which they agreed to limit their power to regulate, but now it is multinational corporations through something called investor-state arbitration that are directly challenging the power of states to regulate. So this is the topic that I will discuss. In light of a pending case, a very important $500 million case between a very well-known drug company and a fairly well-known country. My disclaimer, by the way, is that I was approached by both sides in this case to be their expert, and I picked Canada, so I do not promise a completely objective talk, but if you believe in completely objective talks, we need to talk. This is the background of this case. So two patents, or patents if you prefer, were issued in Canada on two drugs owned by the Eli Lilly company. And as is extremely common in every country, including India, those patents were challenged. The validity of those patents was challenged in court, and the patents were invalidated by the Federal Court of Appeal. And Lilly then tried to go to the Supreme Court, but in Canada, as in many other countries, you don't have a right to go to the Supreme Court. They have to want to hear you, and they refused the case. The Federal Court of Appeal based its analysis of the validity of the patent on something called the promise of the patent doctrine. And basically, the debate, without going into all the weeds, is this. Lilly says, we promise that our drug, in our patent application, we promise that our drug would do certain things. It doesn't. But it doesn't matter. It still does something useful. Therefore, we should get a patent. Canada said, the court said, you promise something in a patent. A patent is a little bit like a contract between you and the state. It doesn't do what you said it does. Your patent's not valid. Now, we could have a very interesting policy debate as to whether that's the right policy. But the question is, can a country make that decision to adopt that policy? That's really the heart of this matter. And this was challenged by Lilly under the Investor Protection Chapter of NAFTA. NAFTA is the North American Free Trade Agreement entered into in 1993 between Canada, Mexico, and the US, and essentially the first major trade agreement to include investor-state provisions. For those familiar with the TRIPS agreement at the World Trade Organization, I think many of you are, NAFTA is very, very similar to TRIPS. However, it doesn't have all the provisions in TRIPS. There are two very important articles, 7 and 8, in TRIPS, which describe the policy objectives and principles underlying intellectual property protection that are not in NAFTA. So what is investor state? Essentially, this is a chapter in a trade agreement, or it could be part of a bilateral investment agreement that creates a special arbitration system allowing a multinational corporation that invests in a country to sue that state directly into this special system. It's a one-shot deal. There is no appeal, unlike the WTO. And as I will try to show a little later, it's quite different from the world of trade as we think of trade disputes. Why is it relevant in India? Well, because India is going to be bound increasingly by investor-state provisions. The TPP might die, given the result of the recent US election, but it is in RCEP, and in hundreds, literally, there are 3,300 bilateral investment agreements and free trade agreements in the world. Most of them have ISDS provisions. Interestingly, in fact, India has taken a position on investor-state dispute in the RCEP context. The RCEP text on ISDS is very similar to the TPP. India and China have pushed for a little bit more flexibility for the state to regulate without being challenged. Korea and Japan are pushing in the other direction, so it'll be interesting to see what happens. I want to show you in one slide how these two worlds collide. The worlds of multinational corporations investing around the world on the one side and countries on the other. This is a quote from the Lilly brief in the case. If Canada can unilaterally reinterpret a core legal term in such a stark manner, remember this was done by courts after a full debate between Lilly and the government of Canada, with such severe consequences, etc., they say these internationally accepted meanings, in other words, there's one meaning for certain terms that they prefer, and they call it internationally accepted, could be susceptible to unilateral redefinition. That's the view of a multinational company. The view of a country is these are sovereign decisions. I'm a country. I have the right to make decisions. They're not unilateral. To call the decisions made by a country unilateral is to take away their sovereignty. Because a country necessarily acts unilaterally when it makes sovereign decisions. This is where you can see these two worlds colliding. To put this in other words, Lilly is trying to use the notions of indirect expropriation and fair and equitable treatment in the investment chapter to challenge the invalidation by Canadian courts, in which Lilly does not deny that it received fair treatment and due process. But it's saying Canada could not make that decision. Courts in Canada could not make that decision. Interestingly, in NAFTA, you would think this is not subject to investor state because there's a provision in Chapter 11 that says basically the revocation of an intellectual property right is not subject to investor state arbitration. Lilly's entire case is based on the last 2.5 lines. To the extent that the revocation is consistent with Chapter 17. Chapter 17 is the TRIPS equivalent in NAFTA. It's the substantive patent law obligations. And basically Lilly says, therefore we can challenge Canada's IP regime in investor state. Canada responds, no, this is a logical fallacy. If it rains, the streets are wet. Therefore, if it's under Chapter 17, it's not subject to ISDS. But if the streets are wet, it does not mean it rained. It may be that someone spilled water. Maybe someone washed the street. You cannot flip this provision. In other words, this is a shield, not a sword. And this is one of the issues that the arbitrators must decide. I want to show you how far Lilly's argument goes. This is another quote from their brief. Lilly, quote, relied on Canada's patent law when it sought patent protection. Patents were issued after a, quote, careful review by Canada's patent examiners. This means that any revocation of a patent, this happens thousands of times every year around the world, including here, is indirect expropriation, if you believe this argument. What is perhaps even more troubling is the use of the fair and equitable treatment. Basically, Lilly says under fair and equal treatment, and fortunately so far our tribunals in this ISDS context have not accepted this argument for the most part, but the argument is this. Fair and equitable treatment of an investor implies that a government will not make changes to its regulatory structure or policy. At least not major ones, or ones that we see as negative, or that Lilly calls radical. In other words, a government only can make tweaks to its policy structure. That's okay. Tweaks are okay, but a significant change, not okay. Or, at the very least, you will have to compensate us for that regulatory change. This is kind of an international efficient breach doctrine, right? If you're familiar with the contract law theory. So Canada, yeah, sure, go ahead. Breach your obligations not to change your policy, but if you change your policy, you must compensate us. Imagine if every corporation, and actually imagine if every citizen had the right to be compensated for any change in policy. How far this goes intellectually and in other ways is actually quite troubling. So Canada did respond, as you can imagine. All these documents are available online, the briefs of the parties and so on. This is not, these are not secret documents. Essentially, Canada said, this is time-barred. I'm not going to go into the details of that argument. Canada has challenged the fact that an investor has a legitimate expectation that there will not be a policy change under the fair and equitable treatment regime. It said in any event, Lilly did receive fair and equitable treatment. They said, Canada said, patentability criteria change all the time. Courts change them all the time. For those familiar with US law, US Supreme Court changed US patent law radically in two very well-known cases, Alice versus CLS Bank and KSR versus Teleflex. The fact that patent law is different between Canada and the US is not itself a violation of international law. Remember, Lilly said that the doctrine is called the promise of the patent was radically different. Well, this is a quote from a 1981 Supreme Court of Canada case that says a patent will not be useful if it will not do what the specification promises. This is a quote from an English, not a case, but Halsbury's Laws of England, and the Supreme Court of Canada said in 1981, Canadian law is to the same effect. So where Lilly says he sees a radical change there, I'm not entirely sure. Just so that you know, under Article 1128 of NAFTA, other countries, therefore the United States and Mexico in this case, are allowed to file briefs. They did both support Canada. Essentially, the case will boil down, possibly, we haven't seen the decision yet, to the right to regulate. Does a country have a right to regulate? And if so, to what extent? In a recent case between Philip Morris and Uruguay on the packaging of tobacco, the award went for Uruguay 2-1, however. There was a dissent. And by the way, the dissenting member of the tribunal is Lilly's arbiter in the case against Canada, so that's an interesting little tidbit of information. But basically, the Uruguay case turned on this notion that a government has police power to make public policy decisions without having to compensate investors. In a previous, very well-known 2006 award, the tribunal referred to a well-established international law norm of the normal exercise of regulatory powers. So I'm hoping that the Lilly case comes out the same way. But again, basically what's happening here is you have an investor saying it is indirect expropriation for a country to make a quote-unquote unilateral change to its policy that we consider negative and radical. Here, for those of you who know trade law, why this is a little concerning. In trade law, we have safety valves. There's a general exception, Article 20 of the GATT. There's something similar in the GATTs. These are the General Agreement on Tariffs and Trade and Services at the World Trade Organization. And in the TRIPS agreement, there's safety valves on compulsory licensing, which India is quite familiar with, and for something called the Paragraph 6 system, which allows countries such as, for example, India, but Canada too, have used it, to export pharmaceuticals to countries that are too poor to pay for them and unable to make them because it's too complicated to make these compounds. So in state to state, we have safety valves. By contrast, in ISDS, we have none. None of this exists. Investor state is not subject to these general limits. So as Kate Miles says, there's very little room in ISDS, at least doctrinal vehicles or rooms or vectors with which to push public policy, which leads to these big battles between trade law, in which we have this idea that trade law should not live in, quote, clinical isolation from international law, that it's part of international law, and expropriation, where in investor state, all you care about is, did the investor have property? Did the investor lose property? Now, I think everyone in the room might agree if we say, okay, you build a plant in a country, the government takes your plant. That's expropriation. Should they compensate? Yes. I don't think there's a big debate about that. This isn't what this is about. This is about patents or property, as you're going to hear from Shamnad in a few minutes. Actually, if they're property, they're very shaky property. And so if they're property, then if you revoke that property, because the court says the property should not have existed in the first place, it was invalid, to call that expropriation is a significant stretch. Yet, in patent law, we understand this, that it's not property in the normal sense. We know patents are property, if they are at all, for a purpose. They create incentives. Whereas in a typical property law context, you don't ask, why did they create this property right on this house? In patent law, we do. So I'm going to skip this slide. These are theories that will be discussed, or discussed in the paper I'm writing on this, that other people have suggested. But there's one that I'm actually pushing a little bit. And I'm going to take the last couple of minutes to talk about these two solutions I have in mind. The first is this notion of stipulation pour autrui, or stipulation for another, which is a notion of civil law, contract law, which basically says A and B make a contract saying that C can live in the house owned by A. Right? A and B make a contract for the benefit of C. But they say if C opts to live in A's house, C must pay a rent of X. C can accept that and go and live in A's house. It's not abnormal to impose an obligation on a third party who's a beneficiary of a contract. Are there no obligations whatsoever if you're an investor? Just, oh, you're given this right to sue. Nothing is asked for you in return. Well, they might say, no, we need to invest. Where you invest in a patent? Because you paid $300 to the government to get your patents? That's your investment? They say, no, we made the investment in another country, our home country, where we invented this drug. And so you can see how this is getting a little interesting. Some governments, Australia has made a very strong statement against ISDS as a way of reducing its regulatory flexibility. This, if anyone in the room knows which flag this is, I will pay you coffee. Break. This is the flag of the French-speaking part of Belgium. And they challenged the Canada-European Free Trade Agreement specifically a month ago on ISDS, saying it reduces regulatory flexibility too much, and it's going to the Court of Justice of the European Union, so we'll see what happens. This is my last slide. My suggestion is to build express or explicit interfaces and safeguards in ISDS. Professor Okadiji, a good friend of mine, wrote that ISDS should be narrowly tailored, so this isn't an entirely new idea. The EU is pushing for this in its trade deal with Canada, and in TTIP, the deal that's being negotiated, at least may still be being negotiated by the EU and the US. Safeguards that are there now for labor laws, environmental protection, but not IP, and not other things like privacy, for example, and data protection. I said this was my last slide. This is truly the last one, where I'm proposing, if you're familiar with the Vienna Convention, this is a convention that tells any international tribunal, the WTO, but also ISDS tribunals, how to read treaties. I'm suggesting a Vienna Plus, so basically having an ISDS set of provisions that would tell an ISDS, a tribunal, if you have two ways of reading the treaty, one of which allows the country to keep its right to regulate, you should prefer this one. In trade law, we don't have these tests. In trade law, we have tests like necessity. Was this measure actually necessary? If not, you cannot violate your trade commitment. Or there's also the least restrictive approach. Is this the least restrictive regulatory measure that the country could take? When you're talking about things like public health, I'm not sure that that's the test we want for the future. So that is kind of my suggestion. It would fit very well with the European proposal to have a worldwide kind of tribunal, and we could put that as part of its statute. And I'm hoping that India will play a role in RCEP in implementing this new model. I lied about the last slide, but this is the last one. Thank you very much.